Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer. And the question today asks about the value of adding on or before in front of the closing date. So let's say the closing date is January 15th. And the purchase agreement says that the closing date will be on or before January 15th. Is that a useful tool, or better yet, if the agreement says that, does that mean that one of the parties can force the other party to close before January 15th? And the answer to the question, to both questions really, is no. It's not a useful tool, and it doesn't mean that either party can force the other party to close prior to January 15th. In our example, the closing date is January 15th. The purchase and sale agreement, like any contract, already can be amended by the agreement of both parties. We don't need to say on or before so that the parties could in the future amend the purchase and sale agreement to close before January 15th. The parties, by contract law, already have the ability to amend the purchase and sale agreement or any contract by mutual agreement. So if the parties agree that they want to advance the closing date so that the transaction closes on January 10th instead of January 15th, the parties just have to enter an agreement that says the transaction will close on January 10th. Adding the on or before language does not give them the ability to mutually agree to change the date. They already have that ability. So the on or before language adds no value in that respect. So then the question is, if we have the on or before language, can the buyer, for example, force the seller to close before January 15th? And the answer is no. Using the words on or before does not give one party or the other a superpower to be able to force the other party to change the terms of the agreement. The words on or before create the impression that one party or the other can force a closing earlier than January 15th, and therein lies the problem and, in fact, the harm of using the words on or before. It is my opinion, as a Washington Realtors Legal Hotline lawyer, that brokers should avoid use of the term on or before in front of a closing date. Now, I know I am going to make enemies, or at least folks unhappy, in the escrow industry, because escrow agents love to tell brokers to write on or before in front of the closing date, with the belief that then if the parties want to close earlier, then they can. Again, it's not necessary to say on or before. If the parties want to close earlier, all they have to do is agree to close earlier. And in fact, almost every escrow company out there has a boilerplate set of escrow instructions, and those escrow instructions include instructions to the escrow agent to close the transaction as soon after the signing as possible. So if both parties sign those escrow instructions and then both parties sign their closing papers, they have in fact already instructed the escrow agent to to close the transaction as soon as possible. So there is in fact no need for escrow agents to worry about the on or before language being in front of the closing date. When the parties instruct the agent to close the transaction and sign the closing documents, the escrow agent is instructed to close the transaction. Why am I emphatic about saying don't use on or before? Because let me ask you this actually. Why would you write on or before in front of the closing date? The only reason you write on or before in front of the closing date is so that one party or the other, or maybe both, believe that they can force the other party to close before January 15th. And that is a false impression. Brokers do not draft contract language that creates a false impression for your client. When you write a purchase and sale agreement, you are engaged in the practice of law. In Washington State, you are engaged in the authorized practice of law. The Washington State Supreme Court has said that you are licensed to fill in the blanks on pre-printed standardized forms. But when you do so, you are held to the standard of care of a lawyer. There is not a lawyer out there who is going to draft a contract creating a false impression in their client's mind. You as real estate brokers should not do that either. And notwithstanding the urging of escrow agents to include that language, you should not do so. You are licensed to fill in the blanks on pre-printed standardized purchase and sale agreements, and in doing so, practice law. Escrow agents are not. You are entrusted by the Washington State Supreme Court to protect buyer and seller interests in the preparation of purchase and sale agreements. Escrow agents are not. Do not create a provision that creates an artificial impression in your client's mind as to what they can and cannot do with respect to the closing date. The closing date is January 15th. That's how it should be drafted in the purchase and sale agreement. If the parties want to change that agreed closing date, they can do so by future mutual agreement. Sorry if this sounds harsh. This is a frustration for many, many buyers out there. I get lots of hotline calls about this question because buyers believe they can close early. They've done a good job. They've expedited their closing process. They're ready to close early. They're ready to move their family into a new home. And seller says, nope, not closing until the agreed closing date. And buyers are upset because the language says on or before. So clearly they ought to be able to close before. Not so. Buyer brokers, don't let that impression be created in your buyer's mind. The closing date is the specified closing date. Specify a closing date and let them know that if they're going to close on some other date, they have to reach the agreement. They have to reach agreement to do so with the seller. If you have questions on this topic or any other, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.